The U.S. District Court for the District of Columbia has issued a decision granting leading global electronic cigarette brand Njoy's motion for preliminary injunctions seeking to prevent the FDA from detaining or refusing admission into the U.S. of its electronic cigarette products. And as a result, that should help ensure that committed smokers have continued access to this alternative smoking product. My guest today is Phil Perry. He's litigation partner in the Washington, D.C. office of Latham and Watkins. Philip, thanks for joining us today. Can you give us a little bit of background on this decision?
You probably know that e-cigarettes, are essentially a electronic form of real cigarettes without all the hassles of secondhand smoke and a number of other issues, and thus you can smoke them in various places where traditional cigarette smoking is prohibited. Well, a number of companies, including our client, have been selling these since at least 2007, and at that point, and until really 2009 or so, it appeared that FDA's view was that it had no authority to regulate e-cigarettes because they were essentially like traditional cigarettes, and that the old 2000 Supreme Court case in Brown and Williamson, that's the name of the Supreme Court case, had prohibited them from regulating tobacco as customarily marketed, which just means for smoking pleasure rather than as some type of therapeutic product. So the e-cigarette manufacturers, including our client, had been selling for a while, and we're under the very clear understanding that FDA didn't view itself as having the authority to regulate or to detain or to put restrictions on the sale of e-cigarettes, again, because they were just like traditional cigarettes, until about 2009. And at that point, it came to our client's attention, and I think to many other sellers of e-cigarettes' attention, that FDA had changed its mind and it started to detain products entering the country imported from countries that manufacture e-cigarettes and refuse them admission to the United States. And so a company called Smoking Everywhere brought a lawsuit to challenge one of those detentions, and we intervened in that lawsuit. And then over the coming months, of course, Congress passed the Family Smoking Prevention and Tobacco Control Act, which then ultimately factored into the decision Judge Leon reached in this case.
Philip, what did the judge decide here with regards to regulating the product?
Well, Judge Leon decided that FDA didn't have authority to regulate e-cigarettes the way we have sold them, the way we have marketed them as a drug under their drug authority, which is the authority that was at issue in that Brown-Williamson Supreme Court case. And the question there is, what qualifies as a drug? If you sell a tobacco product for smoking pleasure, for the enjoyment of nicotine, as traditional tobacco products have always been sold, can that be regulated as a drug? The Brown-Williamson case, the Supreme Court case, said no. And Judge Leon, as part of his analysis here, along with analyzing the new Tobacco Control Act, said no as well.
Now, what happens for the company now? Is there more testing required?
Well, at this point, the ball is in FDA's court. The company, under the terms of Judge Leon's injunction, is free to sell, free to import, and certainly the company is very careful about ensuring that its product is appropriately fashioned and is appropriate for customers' use. But in terms of the new Tobacco Act, FDA would have to regulate, and it said this in the context of the litigation, in order to cover cigarettes. It may choose to do so. It may choose to this was just a preliminary injunction, so to litigate further in the district court, although Judge Leon's clear as to his position on the law here, so I'm not sure they're going to take that course. I'm not sure if they're going to attempt to appeal either. That's another ball that's in their court. So, but under the terms of Judge Leon's order, Smoking Everywhere and Njoy can continue to sell their product, to import it, and so forth.
Before we continue, for our viewers who are not completely familiar with this product, can you explain the technology here and what this product is designed to do?
They vaporize a compound, a liquid cartridge that is derived from natural tobacco leaf, and the FDA has acknowledged that it is a tobacco product under the way they define tobacco product in the new Tobacco Control Act, and but it's derived from natural tobacco. It's vaporized in a battery-controlled device and inhaled as a vapor and not as traditional secondhand smoke as you'd get from a normal cigarette. Well, I advise you to take a look at the website for Njoy, and if customers are interested, they could certainly take a look at that and make a decision. And it's sold only to adult customers, and for smoking pleasure.
How does the company want this product to be classified?
Well, again, right now they're not subject to the drug authority that FDA has, and it's up to FDA to decide whether or not they want to try to regulate the product as a tobacco product under the new Tobacco Control Act. I can't speculate as to what they're going to try to do. They've suggested that they might do that, but that ball's in their court. Under that new act, it's not a situation as Congress passed the act where e-cigarettes would sold in the fashion that Njoy sells them would be subject to any type of ban. It's a question of regulating them under the new terms of that act. So that's again up to FDA, and we'll just have to see what they decide to do.
And finally, Phil, we again appreciate your time. Who is the market for this product?
Well, Njoy sells e-cigarettes for smoking pleasure, for committed adult smokers to have an alternative to traditional cigarettes. They're not sold as a way to quit smoking, to help people quit smoking. In fact, the product is specifically labeled in a way that says it's not that type of product. And so they certainly do not share all the properties of traditional cigarettes, but they're sold for smoking pleasure.
My guest once again is Philip Perry. He is litigation partner in the Washington, D.C. office of Latham & Watkins. I'm Scott Drake, and you're watching the Legal Broadcast Network.